Well, good afternoon, everybody, and thank you for joining us. Hello, Stewart.
Hello, good afternoon.
So we have a very interesting and exciting guest today, somebody who was on the Zack Peter show yesterday with No Filter with Zack Peter, Josh Boswell. How you doing, Josh?
Hey, good, thanks. Thank you very much for having me on.
Well, I appreciate you coming on with us. You're a reporter with the Daily Mail, is that correct?
Yes, that's right.
And how long have you been with the Daily Mail?
Oh gosh, I've been staff since 2019, and I freelanced for them for a couple of years before that, pretty much ever since I moved to the US.
Okay, great. So it's been some time. And when did you first kind of pick up this Lively versus Baldoni story? When did you begin getting interested in it?
So, I mean, I've had a look at it here and there. Some of my other colleagues at the Mail have really been kind of carrying the torch on it, but there was this very interesting thread that, of course, you guys have been pulling too about the subpoena and all of that we really started digging into kind of over a week ago, maybe 10 days ago, something like that, on that particular thread.
Okay. And so what caught your attention about the subpoena?
So, well, I'll sort of take you through the timeline, and then you can see, sort of how my interest got raised. So, a source showed us a copy of the subpoena, and the reason for that was, Brian Friedman, Justin Baldoni's lawyer, was coming out saying, hey, I don't think there is a subpoena. I think actually Stephanie Jones, Justin Baldoni's former publicist, leaked all of these really bombshell text messages to Blake Lively's side. And she was saying, no, it was a court-ordered subpoena. And he said, I don't think that's true. Well, a source came to us and showed us a copy of this subpoena that looks like, it was sent to her and it asked for all of this information. So that was kind of the initial story was, hey, look, there is actually a subpoena. But then we dug into it a little more, and that's, I think, where it got really interesting. The subpoena actually comes from, and this is something you guys have talked about, of course, on your show already, comes from a company called Vanzen Incorporated. It wasn't Blake Lively sending it to, it wasn't Ryan Reynolds, it wasn't one of her other companies sending it to Stephanie Jones. It was Vanzen, which was a company we'd never heard of before. And so, we started digging into that and found this New York lawsuit that was filed in September. It was on September 27th that this complaint was filed in New York State Court, that was extremely vague, very odd to my eyes as a kind of layperson, as a journalist looking into this. And that's why I ended up, talking to you guys, getting your advice on it and your take on it back, when was it? Wednesday last week.
Yeah. So you actually saw the subpoena yourself?
Yes, that's right.
And when you saw that subpoena, did it say like the state of New York on it? Was it a New York issued subpoena as far as you could tell?
Yeah. And so I want to be careful here, because I agreed with the source. The agreement with viewing this was that we wouldn't quote from it directly. There have actually been other media that have done that. Deadline quoted directly from the subpoena in a story, I think yesterday. So, I want to be careful about not breaching my agreement with a source, because, that's very important to us. If we say we're going to do something, we stick to it. If we're going to keep someone anonymous, we stick to that. But what I can tell you is that this subpoena clearly was from a New York State court case. We were able to identify that case from the subpoena. And it was also, from Vanzen. That's clear from the subpoena. So you can kind of like gather what was on there from that. And it was addressed to Stephanie Jones and Jones Works at their New York business address.
Was there any proof of service on the back of the subpoena that had anybody else's addresses to where it was also sent to give these people notice that the subpoena was being served on somebody?
That's a great question. No, that was not included in the documents that we viewed.
So, and when you say it wasn't included, you don't know if it was ever existed, but you did not get a copy of some type of a secondary page, a proof of service showing where the actual subpoena was being served upon.
Exactly, yes.
And if you can disclose this, and if you can't, we understand. Did you have your own in-house lawyers or any lawyers look at this and opine as to whether this was a valid subpoena?
I mean, we've done a lot of checks on it, is what I can say. And, but before we actually got to publication, it involved a lot of, carefully going through, what this was, whether it was valid. I mean, a big part of it was being able to trace that New York case and see, what that was about beforehand. Because there were these allegations that, the subpoena isn't real, but we were able to see that it was linked to this actual court case that was filed, albeit kind of a strange, very vague complaint by Vanzen against these 10 does, these 10 unnamed defendants, who were at the same time, according to the complaint, staff or clients or representatives of Vanzen. So it's saying, okay, Vanzen, I'm suing 10 people, they're my clients and representatives, but I don't know who they are. Kind of odd. But through seeing that being a real case as well, that kind of lent some credence to it. We also did some digging into what Vanzen even is, Vanzen Incorporated. And you can see from the corporate records, especially those filed in California for the company, Blake Lively is down as Blake Reynolds on a 2021 company filing, also again in 2023. So that helped us kind of see, okay, this is a company, albeit a little known one, that is in fact controlled by Blake Lively.
In your digging into this story, Josh, have you found any connection between Leslie Sloan and, with Stephanie Jones and any type of facts that would indicate that this information from the phone that Jen Abel had was delivered to the Lively camp in some fashion so that they knew exactly what they were doing when they did this Doe lawsuit so that they could send out the subpoena to
Jones.
Thank you, Jones. I'm getting my names messed up.
A lot of names.
To get the subpoena directly to her, because obviously they knew to send it directly to her. Do you have any facts that they had a lot of knowledge or any knowledge as to what they'd be getting from Jones if they were able to be successful in getting a subpoena over to her?
Yeah. So let me lay out kind of the two sides on this, I suppose. You've got Brian Friedman, who's saying, firstly, in the lawsuit that Baldoni filed, there was this August 21st call from Leslie Sloan to Melissa Nathan saying, where she was allegedly bragging that she had at least seen this information from the text messages and that, Melissa, she was going to sue Melissa. So that's one thing. That's just an allegation right now. I have not seen, call logs that prove that. Maybe that's something that's going to come out. Maybe Brian has some evidence that he's going to bring into that court case to support that. But at the moment, that seems to be disputed. It's certainly a claim on his side. On the other hand, you've got kind of people close to Jones's camp saying to me, well, look, it was pretty clear from what had gone down already. You can see that there was infighting and there was allegations of briefing against each other. That's kind of what you can see from the text messages and emails that have been made public in these lawsuits now. And so Jones and Lively was aware of this kind of infighting happening, coming maybe from Justin Baldoni's camp. And so it stands to reason that she would want to go after, the person who was in charge of Baldoni's PR. You don't necessarily need a bunch of insider information or kind of leaked texts already to know to go after Stephanie Jones. But the subpoena was kind of interesting in its timing. It was way earlier than what we've previously known to be the official timeline of the courtroom battles, right? So that's one point in maybe in Brian Friedman's favor in Justin Baldoni's side, which is September 27th. That's pretty early on in the process. And then only 4 days after that complaint is filed, you have the subpoena going out. So it does seem quite targeted and pretty speedy that they were kind of launching this campaign to get that information, those text messages.
Yeah. And I actually did go back and look at Exhibit A to Baldoni's complaint, and there is a call log on page 152 of Exhibit A. They show a snapshot of a call log that is supposed to establish that Leslie Sloan called Melissa Nathan on August 21st. I don't have any way of being able to verify this call log, but it is just a snapshot, I guess, of calls.
Or what was discussed.
Yeah.
So I might have skirted over that then. Yeah. So that's interesting. So there is some evidence or potential evidence that they're bringing forward to say there was at least a phone call.
So they say, yeah. And so that was interesting. The other thing that strikes me is that my understanding is that when Stephanie Jones took the phone from Jen Abel, that happened in California. My understanding is Abel went into the office, Jones' work office in California. That's where she worked. She was met by Stephanie Jones, a security guard and a lawyer, and they took the phone from her in California. Now, the question in our minds, when Stuart and I were talking about this morning, you cannot take a subpoena in New York and just automatically enforce it in California. When a subpoena crosses state lines, there's a procedure you have to follow. And that's true, no matter what state you go to. And every state's a little bit different, but a lot of states follow the uniform code now. So in order for a subpoena to be enforced in California, you would have to file it with the California court and get the clerk of the court to issue a subpoena out to Stephanie Jones. And so that's why I was asking you before, was it a New York subpoena? Because at some point, if they were going to enforce that in California, they would have had to have gotten a California subpoena issued. And I'm assuming that you only saw one subpoena. You didn't see two different subpoenas.
That's correct. We only saw one subpoena. It was very much just linked to this New York case. So nothing related to California there. But I want to make sure I'm understanding what you're saying correctly. So the text messages and all of the data from the phone that was obtained by Jones from Abel because it was a company phone, right?
It was on the phone, yeah.
And then you're saying that for Jones to be able to legitimately hand it over to Lively's people, perhaps the subpoena should have been issued through a California process. Is that
if the phone was still in California? And so it begs the question, what happens to the phone? But if you file a lawsuit in New York and you want to subpoena my phone, I'm in California, your New York subpoena isn't going to work in California. It just doesn't carry any weight. And so you would actually have, and it's not that complicated, but you have to submit a form to the California court. You submit your New York subpoena, the California clerk of court will issue you a California subpoena, and that's the one you serve.
And by the way, in California, you would have to, once you got that secondary subpoena, the California-based subpoena, then you would have to do what we call consumer notice. And that's what did not happen in New York. Consumer notice would have given everybody whose information is on that phone entitled to come forward and object and say, no, don't disclose this information. And that's not what happened because of the New York subpoena, presumably on a device that was moved from California to New York.
And that's what I'm getting at is, was the phone moved? Because if you try to subpoena somebody who has a phone in California under California law, not only do you have to go through those machinations to get a California subpoena, but you have to follow our consumer's notice law, which is very different from a lot of other states, which requires even more notice to the person whose data you're trying to get a hold of. I think there's a good chance you would assume if they followed the New York subpoena and they didn't do any of those steps, maybe the phone left California and went back to New York.
You would have to think it had to have gone back to New York because then you don't have to notice anybody with the Doe lawsuit and you go from there. Josh, have you had a chance to speak with Blake Lively's team on this, the lawyers, Ezra Hudson, Mr. Gottlieb? What is their response to all of this?
Yeah, so I went to them for comment on Wednesday last week, 2 days before we published the story, and asked them about all of this, laid it out, what we'd found, and asked them about it. And her representative got back in touch with me. So I've not spoken directly with the attorneys, but it's her PR who got back in touch, and they sent a statement over from the lawyers. We included that in our story, and it's basically it's a pretty caustic wording, accuses Friedman of faux outrage over this. And I think the point that they are making with all of this is, hey, why is Friedman and why is, everyone at this moment focusing on the process here when the actual content is what matters? That's their side of things. They're saying, look, what did the text messages actually show? It showed, according to Lively, a smear campaign by Justin Baldoni. That's what we should be focusing on, the bad behavior that these text messages showed. Now, maybe that's just kind of a messaging ploy to get away from this thing that could, prove difficult for them, the potentially sort of shady way that these text messages came into Lively's hands. But that's kind of more their line. And they're saying, this isn't a big deal. This is totally above board and is a very normal way of doing things. Talking about, referring to this Doe lawsuit that was used to get a subpoena, that was done in a way that they didn't have to alert Justin Baldoni. They're saying this is normal lawyering, and just because I'm paraphrasing here, this is not the direct quote, but the suggestion from them, I think, is just because Brian Friedman and Justin Baldoni weren't aware of it until I told them about it, then that kind of sucks for them, and it's just normal legal process.
Josh, as an investigative reporter and covering this story, does that pass the smell test for you?
Well, it makes me interested. It makes me interested to dig more into it. It's why I thought this was an interesting story. As a layperson, I look at this and I think this looks maybe underhand. Why use Vanzen? A company that seemingly has nothing to do with the legal case here. Why would you put such a vague lawsuit, with Doe defendants? That makes me suspicious. And when then I ask them about it and they say to me, "Don't worry about that. Look over here instead."
Right.
That does make me think there's maybe something to it. On the other hand, that's kind of what they're saying about Friedman. They're saying, no, he's trying to distract you with this process stuff, and the real story is, the content of the text messages. I think the other thing is, I am not a lawyer. It's why I called you guys up, and it's why I spoke to Rob and a couple of others, and I did get a range of views, which kind of was reflected in the story about this. You guys, I think, and were kind of surprised at it, and correct me if I'm wrong, you thought this was an odd way of doing things, and was maybe something that could open up them to a claim of I don't know, being underhand, for example, or even sanctionable activity. That's where maybe Friedman is taking it. I did speak to other lawyers who said, no, this isn't an abusive process. For example, I was chatting to Dina Doll, who has followed the case. She's a litigator who appeared in an HBO documentary on the Baldoni Lively thing. And she was saying, look, from her research, from her understanding as a lawyer, this is not sanctionable. This is not against the rules, but it just looks bad. The real impact here is at the trial. If we get there and Brian Friedman gets to put this stuff in front of a jury, that's where you could have a real impact, that then, it starts to help cast Blake Lively as someone who's willing to do things in an underhand, maybe unethical way without actually accusing her of, breaking the legal rules here.
Yeah, I think that's the upshot of this whole thing, is that the Lively camp effectively handed Friedman a gift. And now he's going to be able to beat that drum. And whether you think it's ethical, unethical, whatever, if I was Friedman, I would say exactly what he said. I think he expanded on his comments on the Deadline article and said even more. And of course, every motion you see from here on out is going to be the same thing: abuse of process. So it'll be interesting to see how it goes. I would love to know what happened to that phone, how that ended up getting produced under New York law versus California law when it was in California when they took it away from Jen Abel. So it'd be interesting to find that out. I don't know if you ever could.
This story opens up that whole avenue of investigation for Brian Friedman in the case. It makes it an issue, I think, that then he's going to be able to ask the judge to approve him getting discovery on that whole process. And so maybe we will find this out. There was one other thing I wanted to ask you guys. I saw some tweets that someone online, this user Ludwig, I want to give proper attribution here, but it's just an ex-user whose username is Ludwig, spotted in a Deadline article that I mentioned before, right? Deadline actually ended up quoting from the subpoena. And they said that the subpoena it was asking for information from December 1st, 2022 onward. So pretty broad, quite a large time span. That's what Stephanie Jones was being subpoenaed for. I wouldn't have gone into that detail otherwise, but since it's been put out there by Deadline, I think it's okay to discuss. And you compare that, and this person did, with the application for discovery that Friedman used, that was shot down by the judge. Sorry, that Lively used, that was shot down by the judge, that was asking for just that, information from December 1st, 2022 onward. And the judge was like, no, that's too broad. And so, is the judge going to be a little bit annoyed now to find out that actually this stuff had already been gotten by that team in this kind of at least unusual way, through the New York legal process? What's your take on that?
Yeah, I think so. I mean, I think there's a good chance the judge may find that displeasing to be able to look at that and say, in my ruling, he had limited it to August of 2024 forward, not back to 2022. I think the bigger issue I would have with it as a judge is this is confidential and private information of Jennifer Abel, and also was potentially confidential communications that belong to Wayfair. And Stephanie Jones did have a confidentiality agreement with Wayfair. She was supposed to keep their information confidential. I think as a judge, I would say it seemed like you kind of spilled a lot of private information to people who had no notice of this. And that would be the part that I would take issue with. And then the question is, well, what's the remedy for that? What am I going to do about it as a judge? And one of the things you could do is say, well, I'm not going to allow this evidence to be used until you obtain it properly in this case. And then everybody can be notified. You can file your motions. We'll decide the motions. And that would probably severely limit the amount of text messages that would come in under that scenario. But it'll be interesting to see how Judge Lyman feels about this and how he deals with it. He is a federal judge, and federal judges, they don't mess around. So, they tend to be a little bit more strict than state court judges by and large.
Yeah. And so, I mean, what I'm looking out for now is these, filings from Friedman in that SDNY case. What's he going to say? What's he going to put on the record there? And either accuse Lively of or make as a point here as an attack in the case. So, what do you think his particular angle will be in the upcoming filings?
I mean, if it was me, I would beat that drum as loud as I could. So every single motion, even if it had nothing to do with discovery, I would talk about how Lively engaged in an abusive process. And that's the gift that they gave Friedman, is that he can make this an issue, and he's going to make a central issue to everything he does. And at some point, when you keep beating that drum, it has an effect. It gets through to the judge, it gets through to the other parties. It can change the narrative and change the focus of the case in that sense. So, I mean, I think you're going to be seeing it used a lot. What do you think, Stewart?
I think that it matters what the facts are in September of 2024. What did Blake Lively and her team know? And if they were truly just trying to, they heard a tip that somebody has some information and we don't know what that information is. We don't even know Justin Baldoni is involved, or Jen Abel, or Jed Wallace, all these names that we all know now that we attribute to ourselves. And we say, oh, everybody must have known about this in September of 2024. If this was a truly discovery, if this truly was, we don't know who to sue, so we don't want to put our famous client in the public light. We're going to use a corporation over here to keep it kind of private, and we're just going to see. We've kind of heard that Stephanie Jones has some information that may be helpful to us. She won't give it to us unless we subpoena her. And so, if that's the case, I think that Blake Lively and her lawyers don't look as bad. But if Jones had already given this information, they have all the information, and now they're trying to kind of come back and re-engineer how they're going to get this information so they can have it appropriately and then use it for the trial or discovery or whatever the case may be, then I think it looks bad. Was it legal? I have to say, after some reflection on what they did here, I kind of admire the move. I admire the chess move here. It's very ingenious to think about. Using New York law, the statute says that if you sue somebody, you only have to notify parties when you send out a subpoena, and you can send out a subpoena instantly once you file the action in New York, which is very unique. I've never come across that. In California, we have a discovery hold. We also have to notify people that are subject to the information on the phone. And Josh, as you know, on a phone, it's not just Jen Abel's information. There's lots of people's information on there that's private, and people don't want this information. There's gigabytes of data that have nothing to do with Lively versus Baldoni that may be very private in nature. So, this to me it's worthy of you guys looking into this further and doing more research to find out what was known at the time. And that's exactly what I would say that Brian Friedman's going to be doing in discovery. He wants to know, what did they know? When did they know it? And if he can show that they knew all of this stuff before doing this Doe lawsuit, I think the court is not going to be happy with it at all.
One thing I would add to that is that this whole sort of ingenious scheme, if you want to call it that, or plot, plan, whatever, you're only able to pull it off if Stephanie Jones works with you, right?
Correct.
If she had turned around and run back to Baldoni, that's it. He then is tipped off to everything. And it relied on her being at least just willing to hand over everything, if not kind of, some conspiracy of working with them and leaking stuff ahead of time. At least when she got the subpoena, she had to say, all right, fine, I'm not going to resist this at all. And that's the guidance that I've got from people close to her, that, and in fact, the quote from her lawyer was something, it was to the effect of, she's got nothing to hide. Why would she fight the subpoena? And there's no, record of her filing anything to try and stop that.
It's because it's not her data. That's why.
Yeah.
It's not her life. It's not her private information. And I do think, and it may be that Blake Lively's lawyers actually end up throwing her under the bus at some point too, because they're saying, hey, we sent her a subpoena and she responded to it. And Keith and I have been talking about this. What she should have done, it's very simple to object. You don't even have to file a motion to quash. You're a non-party. You just check a box, or you can just send an email, a one-liner, I'm objecting to this. And moreover than that, you call up Baldoni and Wayfarer and you say, hey, I know it ended badly between us, but I just want you to know somebody's coming for your private information. Let me turn this over to you. You guys fight this. I don't want to have to fight this. And for whatever reason, she didn't do that. So it does look like she was perhaps willing to participate and give the information. Yes.
But you're right, Josh. It doesn't work without her participation.
Yeah.
Yeah. Right, well, if you've got any more questions for me, shoot me one more and then I'll have to dash. But thank you very much for having me on. Fascinating chat.
Well, appreciate your time, Josh. I'm glad that you made the time for us. I mean, I guess my last question was, what's next? What else are you looking at? Or are you just kind of keeping your eye on everything? Or where do we go from here?
Yeah, I mean, really, it's like I mentioned, it's Brian Friedman's, follow-up filings to this. We're yet to see what he says in court or on the docket on the basis of this information that's now come to light. And look, when I spoke to Brian about this, I spoke to him on Wednesday, like I did, everyone, and he seemed genuinely shocked. I don't think he had any idea about the Vanzen lawsuit in New York. He'd been, obviously the subpoena was being talked about and he'd been trying to get a copy of that, he said, but he seemed genuinely surprised at the whole backstory of how this came about when I asked him about it. So yeah, I'd like to see what he files next, and then we go from there.
Fantastic. Well, thanks again for joining us. Your reporting has been fantastic. We've obviously enjoyed it very much, and keep up the good work.
Thank you, Josh.
Thank you. All right, cheers. Bye.
All right, Eric. So I do want to just mention, so Josh was on No Filter with Zack Peter this morning. Zack gave us a shout out and suggested that people watch our interview with Josh. And I thought that was a great discussion. I really enjoyed talking to him. And I think Zack Peter, from my understanding of watching his show this morning, he is going on the road. And so for people who want to see more of Zack Peter live, go check out his live performances that are coming up. I looked at the cities though, Zack, and there wasn't San Diego. So what's up with that?
Yeah, Zack, San Diego, come on. You can fit us in.
Yeah, add San Diego.
All right.
You can do it.
Yeah, LA is the closest it gets. But yeah, he's coming to a city near you. You can go to his YouTube and check it out. But yeah, I got a ton of great questions whenever you guys are ready.
Do you want to talk about the Atlantic real quickly?
Yes. So there's two things I want to cover first. So first off, the Atlantic. So Stewart and I were quoted in a article in the Atlantic. The reporter was Caitlin Tiffany. And the title of the article, let me get it up here, because it actually made me laugh out loud. We didn't know what the title was going to be. The title of the article is "Who Reads Entire Lawsuits for Fun?" And so that was the starting of it. And it was actually quite interesting. She talks to a number of different creators, ourselves, and a number of different people who are covering the Lively versus Baldoni case. And her whole focus, I guess, is, why is this fascinating for people? Why is it fascinating to sit here and look at legal filings and all that? And I thought she did a nice job of kind of writing that up and discussing it. And you were quoted quite extensively in it, Stewart.
Oh, was I? Oh, great.
Oh, yes.
All right, good.
You said many brilliant things.
Oh, okay. ChatGPT was there to help.
Although she did say that, with all due respect, our Ask Two Lawyers videos are breathtakingly boring. But I think
I'm very proud of that comment.
Yeah, I know. Yeah. Well, I and it's not the first time we've been called boring. So, but anyway, it's a good article, and we have a link in the description below.
The one thing I'll say about Caitlin Tiffany is that when she interviewed us, sometimes you get reporters that interview you and they, we interviewed with her for 30, 45 minutes.
Yeah.
And then they cherry pick 2 or 3 comments that you say that could be taken any which direction.
Right.
She didn't do that. I mean, I think she was very accurate in how she quoted us and talked about us. I thought it's overall a very pleasant read. So if you want to read something interesting about what's going on, with the flattening of content creation and how content creators are really pushing the news these days, take a look at the article. It's very interesting.
Yeah.
And we do have it linked in our under the show description today.
Yeah. So there were more quotes by Friedman and Hudson and Gottlieb in the article this morning. And it was, gosh, what is this from? This is Justin Baldoni damns Blake Lively for sham lawsuit. Actresses' lawyers respond. And then the Deadline article. The thing that was interesting, Friedman's statement was a little bit more expanded, but it was along the same lines as what he said in the Daily Mail article, that to his point of view, this is an abusive process. He added one more thing that I thought was interesting. He says that there's nothing normal about this and that officers of the court have a duty of candor to the court and an obligation not to file fictitious lawsuits that have no basis in fact or law. And so what basis in fact or law did that lawsuit have in New York? And it is true that as lawyers, we are officers of the courts and we're not allowed to file lawsuits that have no basis in fact and law. And so it did kind of make me wonder, do you think there was anything there improper about filing a lawsuit that has no basis in fact and law? Or was there at least, because it's a very broad standard. It's not like if he has any statement of fact and law, it works. So what are your thoughts about that?
It really depends on what the lawyers knew and really Blake Lively knew in September of 2024. And again, it's so easy for us to impute knowledge to people that we currently have. We see this happen in lawsuits all the time where we're preparing a client for a deposition and they now know all the facts of the case. And so then they start talking about those facts, 2 years ago. And it's like, no, you didn't know those facts 2 years ago. So, it's kind of one of those things where lawyers, they hear a tip from somebody, for example, let's say that there's some good information to get from Stephanie Jones. Stephanie Jones refuses to speak to them. I'm just making stuff up here as I go. I don't know if this Stephanie Jones refuses to speak to them and they say, how can we get this information? We don't know if it's good information, bad information. So why don't we do this privately through this fictitious entity, Van Zandt, which there's nothing wrong with having a fictitious entity. It's just that they're keeping it private. So it's not Blake Reynolds or Blake Lively or Ryan Reynolds or whatever, because that's going to get picked up by the media.
Yeah.
And they say, we're going to go ahead and issue a subpoena and we're going to do Doe defendants. And the great thing about doing Doe defense is you don't have to serve anybody because really we don't even know who we're going after. We've just heard that there may be something we need to get here. And so then they issue the subpoena and they get all this information. And it turns out to be a treasure trove, which, they learn probably about Jed Wallace for the first time. They learn about Melissa Nathan. They learn, all kinds of things. That's putting the best view of it on the Blake Lively team. That is, if that's what happened, then that would be, in my mind, good lawyering.
Their best argument, too, of defending what they did.
I wouldn't even say I have to defend what I did. I did what lawyers do. I got a tip, and
Right.
You don't impute knowledge to me, 3 months ago that I have today. But I want to spin it the other way too, and that is if they already had all of the text messages, if they already knew who Jed Wallace was and Jen Abel and Melissa Nathan, and they saw everything and they realized this is something we need to get through the discovery process. Then this does, in my mind, it's my opinion, this looks wrong to go forward with a Doe lawsuit to cover up essentially all the information you have. And so nobody out there, nobody in the jury pool, nobody that's watching all of this knows. We don't know. Was this something that, was just good lawyering and very sharp lawyering and the strategy involved was in my mind admirable. I mean, wow, this is a great way to do this if you're not trying to cover up the fact that you already have all this information.
So it comes down to what you knew, because what you knew goes to your intent.
Correct.
And so if your intent is, I already know that this stuff exists because Stephanie Jones showed it to me.
Right.
And now I want to be sneaky about getting it. That's a bad intent. If your intent is, I don't know what's going on and I don't know who is suing me for or hurting me for what.
Right.
Then doing some investigation through this type of process is not a bad intent. And so that's why I guess what they knew is so vitally important. And they, in their response, Hudson and Gottlieb, their argument is there's nothing untoward here, just conscientious and thorough investigation. And the lively parties acted upon reliable information, employed common tools such as Doe lawsuits and civil subpoenas that are entirely lawful and appropriate for pursuing claims. But let's go back just for a moment to that issue of if you issue a New York subpoena, you cannot enforce it in California.
You can if you go through the California courts, but yes.
You have to follow the process.
Correct.
And then there's an added problem with the subpoena in California is that in California, we require consumer's notice.
Correct. It's
a unique law that we have. And, it requires that you give the person whose data you're going after, that's private information, you have to give them notice.
Right.
It doesn't matter what it is. It could be phone records, medical records, financial records, your bank accounts, whatever.
It makes sense.
It makes sense.
And many people think California overregulates everything and has too many laws. I actually like consumer notice because
this one's good.
If somebody's coming after my cell phone and I'm not part of a lawsuit, I don't want people seeing my cell phone and my data without at least having the opportunity of due process to stand in front of a court and say, I don't think you should give this information because 99% of it has nothing to do with this case.
And I think it's safe to say there was no consumer's notice with this subpoena because if there had been, then Baldoni and Wayfair would have known about it. They would have received the notice.
Correct.
And Jennifer Abel too, for that matter. So it doesn't seem like there was consumer's notice. It doesn't appear based on what we know that this New York subpoena was ever filed in California in order to make it a legitimate California subpoena. So that means it was a New York subpoena that apparently was carried out in New York.
Where a phone was moved from California to New York.
Presumably.
So you have a device, an electronic device with lots of data on it, presumably going to New York.
Because we know it started in California because that's where it was confiscated from Jennifer Abel.
Right.
And so again, I think Josh made an interesting point when he said, well, none of this could have happened if Stephanie Jones hadn't been willing to be cooperative in this effort.
Can I ask you a question?
Yeah.
What if the data was sent from California, like it was downloaded here in California and it was on an expert's computer somewhere in Los Angeles, and that's where it resided until the subpoena went to Jones in New York? I'm assuming it went to her in New York. And then what if the information is transferred from California to New York? What happens then?
That could work. I mean, it's a company that has offices in New York and California, so you could subpoena them in either office, and they may have already downloaded the data, and then it's like, well, you can just get it from us out of our New York office. That could work. But then it also, if that were to have happened, it does suggest cooperation. That somebody went to the trouble of downloading this in a way that you would do it for litigation and have it ready to go. So I think.
Do you think that Stephanie Jones, and I'm interrupting you, but I'm doing it because I want to.
That's okay. I'm glad you're not doing it because you don't want to.
Well, sometimes I don't want to, but sometimes I have to.
Yeah, that's true.
But Stephanie Jones, and again, this is just, we want to hear what she has to say. We want to see what she says in court, but it does appear that there wasn't much of a fight here on her part to, once she got the subpoena, it looks like it was complied with relatively quickly.
I mean, if we were given a subpoena that asked us to hand over something from a former client, even a former client that, maybe we didn't care for, we would take certain precautions before we hand it over. We would immediately object to the subpoena. We're not going to comply. We would send notice to the client. Hey, client, we received the subpoena. Here's a copy. Figure it out. If you don't want us to represent you, go get a lawyer and figure it out. And then we're not going to hand over anything until either there comes an agreement between the person whose information it is
or a court order.
And, that's the reason why you go through those steps. Number one, we have an ethical obligation to do that, but also just to protect yourself and your business so that you don't later get sued by the client, which is exactly what Wayfair is doing, is that now they filed a lawsuit against Stephanie Jones and Jones Work, claiming that they improperly handed over data.
And Stephanie Jones we've gone through this before, but you went through the engagement letter that she had with Wayfair, and it had, a couple paragraphs over almost a page of confidentiality requirements, right?
Yeah. So even though she's not a lawyer, she doesn't have our ethical duties, she still had a contractual obligation under the confidentiality agreement that she had with Wayfair. And so I think that takes a certain number of steps. Now, it could be that her lawyer says, well, once I get a subpoena, I have the right to comply with it.
Right.
I mean, I guess you do, but I think that if you're really going to be careful and protect yourself from future lawsuits by former clients, you would follow a different procedure.
Yeah. And again, when they say that Stephanie Jones has nothing to hide, to me, that misses the point. It's not her
Right.
phone. I mean, it's her phone. It's her business phone, I suppose. But the data on it is not. I mean, it's data that belongs to somebody else.
Well, and I saw a comment to one of our last video where it says, "Well, yeah, but did Stephanie Jones hand over her own phone?
no.
No, she handed over Jennifer Abel's phone.
Right.
So
right.
if it was really a subpoena, then why not? Because Stephanie Jones also had text messages with Wayfair and Baldoni. So why didn't she hand over her phone?
Right. And I don't know that Jennifer Abel has any culpability here because she was met at the Los Angeles office surprised by a lawyer. That's intimidating. By a big security guard who
Yeah.
especially stood, according to her, stood between her and leaving the room. And there was also a forensic examiner there that wanted to download her phone and her laptop. And, she was promised that if she gave the phone to them, that they would port this number that she had had for many years. It was valuable to her. The number was very valuable to her. She'd had it since high school or something like that. And so she went down to the Verizon store, I forget which store she went to, and then she basically got stood up.
Yeah.
And, and to think also that all of her data was on that phone. I mean,
know.
that's so, there's some
And banking information and who knows what else.
Yes.
I mean, she couldn't even, and she says that in her lawsuit, that I couldn't even get into my bank accounts.
Yeah, I have all my medical stuff on my phone. I mean, it's
terrible.
I wouldn't want anybody seeing any of this. Well, nobody wants to see it, but I wouldn't want anybody to see it anyway. So,
yeah, I peruse it every morning. I issue a subpoena and I get it every morning. All right. Well, what do we got for questions, Eric?
There's a ton of good stuff that has come through. I'm going to try and get to this. Whoever was first might be fair.
Can I just jump in here real quickly? I see that there's this comment. I normally don't respond to people that are just here to cause problems. Can you go down a little bit? It was just, let me see if I can get to it. Stewart, you seem to be here. Let me start. Let me get it in there. There we go. Stewart, you seem to be really trying hard to defend their underhanded tactics. So CEB 86. This is an example of poor analysis in my mind. I mean, explain how it is that I'm trying really hard to help somebody's underhanded tactics. And I don't even know what underhanded tactics are. Do you think that if these lawyers that represent Blake Lively right now, if they had been the lawyers representing Justin Baldoni, do you think that they would be underhanded lawyers if they were fighting vigorously for their client, trying to do the right things for their client? No, you would be cheering them on, presumably based upon your question. So do better questions. I mean, if you think that I'm trying to support somebody, tell me how I'm trying to support somebody. I'm trying to call balls and strikes. At least that's what I'm doing in my head. I'm not the brightest person out there, but that's what I'm trying to do. So when I see comments like this, I generally just pass by them because I don't think this is what the majority views this case as. But look, these lawyers here on both sides, people don't want to hear it sometimes. They're all fantastic lawyers. They all are doing their hardest work. And if you switch the teams right now, if Brian Friedman represented Blake Lively, he would be doing everything in his power as a lawyer under the law to defend her and to help her. So this has become such a team sport at this point. I'm team Baldoni, I'm team Lively. And yeah, there's not that many people on team Lively. I get that. But we should look at this from both sides, and we should look at the arguments that are good on Blake Lively's side and are bad on Blake Lively's side. And we should do the same thing with Justin Baldoni. I can promise you that Brian Friedman and his team are doing that. They're looking at this case from all angles. And so I'm not here to try to defend anybody's tactics in this case. I am here to analyze those tactics and give my opinion on those tactics. So Seb 86 and anybody else, if you want to quarrel with me, I'm open to it, but tell me how it is. Give me some facts on how I'm defending somebody's underhanded tactics. And sorry that I'm kind of going off on that today, Keith, but it does bother me a little bit.
Well, I think we've said multiple times now, we're here to look at both sides of the argument, and you have to. So if you truly, like you said, Brian Friedman is looking at the other side and trying to figure out the best arguments to make, and you can't do that without looking at the other side's arguments. And so what is Lively going to argue? And we do that constantly in our practice. We're always trying to think, what is the other side going to argue? What's their best argument? What's the way to argue their best argument? Because that's the only way we can strengthen our argument back.
Well, let me ask you, do you think Ezra Hudson and I think it's Michael Gottlieb, do you think these are inherently evil people?
No.
Do you think that these are people that sit around trying to scheme and do illegal things? I mean, are these just people that are just out there to be horrible? And then is Brian Friedman just always trying to do what's right and honest and wonderful? I mean, is that how you view this?
No. I mean, I think, like you said, I think the lawyers on both sides are, they're top-notch lawyers. They're doing the best that they can. Now, and this is true of any case, some side, one side is better than the other side. There's one side that I would like to represent, which, at this point, based on everything we know,
Justin
is probably Baldoni.
Absolutely.
And there's a side that I would not enjoy representing. But if I did represent the lively side, I would give it my all.
Yes.
And I would, because that's what, as lawyers, we take an oath that we have to provide zealous advocacy. That's what we're required to do under our ethical duties. And that's what you do. And so you do the best that you can. I see your point that their intent, when they issued the subpoena, what they knew,
it matters.
It's going to matter.
Yes.
And the reason it's going to matter is that's going to drive Judge Lyman to do one thing or another.
Correct.
So if I were the judge and I found out that Ezra Hudson and all of the gang knew what was in those text messages and you were just trying to issue a subpoena without notice, I would have a very dim view of that. If the evidence were to turn out the opposite, that they didn't know and they didn't know who was really up to what, that would be a whole different ballgame. So I think looking at both scenarios is fair game for us to look at and talk about. And I did go back and look at the Exhibit A where Leslie Sloan called Melissa Nathan. In my mind, I had thought it was a text. And then I went.
When we talked at lunch the other day, you thought it was a text.
I'm like, yeah, she texted her. And then I'm like, well, let me go look at Exhibit A. I want to look at this again. And it was page 152, and it was a phone call. So then you're like, oh, that's not as good because a phone call, it's he said, she said.
She said.
Yeah, it's hearsay. But there was a call. They have a call log. We know that call happened. What was said in that call, they're going to argue about it. I guarantee you that Sloan and Melissa Nathan are going to say two different things about what happened in that phone call. I thought it was a text. A text would be better because you can't refute, with a written word is what was said. But that's not the case. But in any event, there was a phone call from Sloan to Melissa Nathan on August 21st. And I think that is an important fact. Then the question becomes, can you establish what happened and what was said during that phone call? And that's going to be important. And that's going to be testimony of Leslie Sloan and Melissa Nathan. And you'll have to, the trier of fact will have to look at both of their testimony and decide who's more credible, who's more believable.
Right. All right. Sorry, Eric, for that segue.
Don't apologize to me. Apologize to someone else. Just kidding. Okay. Roman wants to know, how is it possible to issue a third-party subpoena so early? I've always been told that you may issue a third-party subpoena only after the discovery period has begun after the discovery period has begun in your case. And it might be different by different states. I thought you guys maybe alluded to between.
Keith, why don't you take a shot at this one? But California, I do want to say Roman Shatow has been here all along with us, and I always appreciate him being here. But go ahead.
Yeah, a lot of great comments. It is different by different states. And so in California, for example, once you file a lawsuit, you have to wait 20 days. We call it the discovery hold before you can start issuing discovery. But you can file in theory, you can file a lawsuit. You can wait 20 days. On the 21st days, you can issue a subpoena. In New York, apparently, they do not have that holding period, that discovery hold. So you can file a lawsuit, you can issue a subpoena. When we were talking to Judge Liz last week, she said that in Florida, lawyers don't issue subpoenas. They have to be issued by a judge. So every state is very different because in California, a subpoena is issued by an attorney, or if you're representing yourself in court, then you have to go and get the clerk of the court to issue your subpoena. So it is different in different states.
So the most conservative and safest way, I would suppose, to have issue subpoenas would be to have a judge give a stamp of approval to them, right? In Florida.
Yeah.
And then the next way that would be safe, but you wouldn't have to keep judges busy issuing subpoenas and reading them to see if there's something that should go out, would be to provide consumer notice like California does. So you have to issue a subpoena along with consumer notice to anybody whose information may be affected by that. And then you have New York here, which all you had to do was file the case and serve all quote unquote parties. But if you only sue defendants, then there's no party to serve and you don't have to serve anybody.
That's an interesting point. So this subpoena would not have worked in California because of our requirement that you must give consumers notice. And so it just wouldn't have worked. You would have had to give notice to Jennifer Abel,
Justin Baldoni,
Wayfarer. I mean,
Chad Wallace.
It wouldn't have worked in this jurisdiction, but that doesn't mean it doesn't work in other states.
Yep.
This one was, a few people were mentioning this one, but Paula says California Electronic Communications Privacy Act, Cal ECPA, protects the privacy of employees even on a company's phone, right?
I don't know the answer to that question, Keith. Do you?
That's my understanding, and I'm not that familiar with that act, but my understanding is there is a privacy that employees have even on companies' phones, and that would make sense. I mean, because that does happen. So
Somebody should send an email to Brian Friedman on that one, because that, it was a phone here in California. The employee was in California. So there may be some issues there as well.
yeah, I think the whole thing should have been a California subpoena.
Yeah, Ricardo wants to know, does Cal ECPA not have any bearing here?
So just, Ricardo, we're going to do some research on that, and we will get back to you on it.
Okay. Jury pool member Jenny wants to know, what is the significance of non-compliance with the formalities required for proper cross-jurisdiction subpoena procedures? That's a mouthful for me.
Yeah.
So I'm sorry. Go ahead, Keith.
No, I'm agreeing it's a mouthful.
Oh, yeah. So we do subpoenas all the time that are outside to other states. And what we do is each state is either part of a group of people that follow the Model Act, or there's people that don't follow the Model Act. So in some states, it's kind of draconian. You actually have to hire a local lawyer, which is frustrating because you have to pay them money. And they have to put the subpoena together for you and issue it for you out of their law office. But many states simply require us to send the subpoena, get a stamp from our court here. You say that we don't have to do that anymore, and I agree with you if that's the case. But we essentially send it to, let's call it Florida. Call it Florida. Then the court there stamps it. We get it issued, and we retrieve the documents. But there's notice requirements along the way that I think is the issue that we're seeing with the New York Doe lawsuit. There was no notice, and so I think there are some notice requirements.
There is, yeah, and the effect, like if you try to serve a New York subpoena in California, the effect is it's not valid. So you cannot serve legal process in California
Unless you jump through the hoops.
Here, which means whoever you serve the subpoena on technically doesn't have to produce it, and you're not going to be able to file a motion to enforce it. So you have to do it the right way in order to get the power to enforce that subpoena.
Right.
Thank you, guys. Next up, this is from Cayuse Mag. You guys had touched on this, but on the subpoena filed, was it to obtain information specifically from Abel's phone? I think the answer is yes. And did Jones hand over her communications with Baldoni and Company too? She didn't, or I don't know.
I don't know the answer to that. And, when we talked to Josh, he was not willing to disclose what exactly he saw in the subpoena to protect his source, which, that's fair game. My understanding, though, and what it sounds like is that the subpoena was issued solely to get Jen Abel's phone. And we don't have any indication that they got Stephanie Jones's phone. But that doesn't mean that Stephanie Jones didn't hand over some text messages that she had that would have been relevant to the subpoena. She could have. I don't know the answer to that.
I'm starting to guess here. I kind of heard from Josh in our earlier interview that the source he has, it was almost like they wanted to prove to him there was a subpoena. So who benefits in this story?
Right.
If there is a subpoena and it's proof that they turned over documents subject to a subpoena, you wonder if the source is coming in. I'm just guessing, pure guess. Is it coming out of Stephanie Jones' camp that this subpoena is leaked to the press, essentially?
I see.
Because
to justify
and show that, look, this truly was a subpoena. Because you 3 months ago, 2 months ago, whatever it was, in January, you and I were putting the timeline together. And you kept saying, where is the subpoena? What case was the subpoena sent out? Because you read in the that Megan Twohey had said that they had looked at the subpoena and they were they'd seen the documents that were subject to the subpoena. And we kept saying, we've pulled all the cases together here. All the cases are either at the end of December 2024 or post that date, 2025. Where is the subpoena? So you were saying that from the very beginning. And then I think other people picked up and the news picked up on it. And so people were saying, I wonder if Stephanie Jones just gave this information, which she might have done that too. We don't know. But did she just give this information? And so who benefits from a subpoena showing up? It's definitely Jones' work or Stephanie Jones, because, hey, I was just complying with a subpoena.
Although if it was somebody in the Stephanie Jones camp who was showing Josh Boswell the subpoena, why not go on the record? Wouldn't you want to say, hey, here it is, I've got it? I don't know.
Maybe this because there would have been more questions about Van Zandt and all the things that we, what was it, Katie over at Without a Crystal Ball. Big fans of her. She, again, I think she did a great job of finding this lawsuit, breaking the story first. I know there were other outlets that were doing the research, and they'd had some of the same information she had, but they had not published yet. So she basically puts this all out there. Maybe they wanted to keep that from happening. I don't know.
Could be.
I'm just guessing.
It's very interesting.
Yeah.
Okay, maybe here's a quick one. Does anyone know how long the judge has to reply to all of this?
He should be replying soon. I'd have to go back and see when the last reply was filed. I don't remember off the top of my head. And then the question is, the judge has to decide if he wants to set an oral hearing to hear argument or not. So the judge doesn't have to. He can rule just on the pleadings, or he can set an oral argument to have the parties come in and argue.
What was this referring to? Was it responding to the Doe lawsuit and subpoenas, or was it to the 12B6?
Yeah, that's a good point. I should have established that first. I was assuming that, and you should never assume, especially in the law. I was assuming that they were talking about the motions to dismiss. There's 4 motions to dismiss that I can think of, which is Leslie Sloan, Ryan Reynolds, Blake Lively, and New York Times. Those are the motions that are teed up right now. As far as all of this stuff going on with the subpoena, I don't think there's any motion before the court for the court to take action on it yet. So we'll have to see what happens.
So Irma de Santiago, that is one of the most pretty names I've ever read.
That is really good.
That's a very nice name. Stewart, your commentary is awesome. Thank you. Don't allow us to upset you. They are just dumb comments. Here's a donation to the charity to donate.
You.
Greetings from, I'm assuming, Orange County.
Oh, well, thank you. Very nice.
Irma, thank you so much for joining us, and thank you for your kind comments. Appreciate that.
And for your donation.
Yeah, speaking of that, Teresa E. said Point Loma. Here.
Oh,
nice.
Point Loma. Nice.
Right in our backyard.
Locals, yeah.
Hair by Teresa.
Yeah, and this is Vi or V wants to know, Sloan threatened to sue Melissa Nathan for the text messages she saw in August before the sham lawsuit. Isn't that a breach of confidentiality by Jones Works?
Possibly. I mean, possibly. And if you look at those confidentiality agreement in the agreement between her and Wayfarer, it says that she had an obligation to keep the information confidential.
But keep in mind, this is what you were getting at on Sloan, right? That Sloan made a phone call to somebody and said, hey, Melissa Nathan, right?
Yeah.
And she said, hey, get ready for a lawsuit.
I've seen the text.
What does that mean?
Right. Well, what does it mean? But if you were to assume that means that Stephanie Jones showed the text to Leslie Sloan, that could be a problem for Jones.
Correct.
But you have to establish that. So we don't have that evidence yet.
Right.
And so that evidence is going to come through the document demands, the subpoenas, and the testimony of the parties. But it'll be interesting to see why would she make that phone call if that's what she said.
And it was Sloan and Melissa Nathan, right?
Yep.
And so, of course, it'll be interesting at trial. I'd be very curious, and in deposition too, what is Sloan's memory of that phone call?
Yeah.
And what is Nathan's remembrance of that phone call?
Well, it would be interesting. I mean, what if Sloan said, yep, that's exactly what I said? I mean, that's not that common that a witness is cooperative like that, but it's possible.
And this is Tanit. I couldn't find the originals back here somewhere, but they say, guys, Bridget is another jury pool member, suggested a new format. You examine a case and you argue against each other, sort of like I've seen other people saying it's like a mock trial sort of thing. What do you guys think?
Yeah. I mean, that's what we do in our cases. Why not just do it here?
Yeah.
But we do it for good reason. I mean, the reason why we do argue back and forth in our cases is to make them better and make our arguments stronger. So I think it'd be fun.
Yeah. I apologize.
I was just going to say, I'd feel bad that Stewart would lose every time.
I'm apologizing ahead of time that, I feel bad for you. Don't let your family watch.
Well, you're not the only one who feels bad for that.
Okay. Shouldn't items turned over as a result of a subpoena be factual and not modified? How can there not be consequences for providing altered evidence in their initial filing? I think that's talking about the text messages.
Yeah. Well, what you put in a complaint, they're just allegations. You don't have to give 100% of every evidence that you have. So the initial complaint, it doesn't matter. It matters in the court of public opinion that they did that because it makes it look like they were hiding something. But in terms of this lawsuit and ultimately trial, the jury's never going to see the complaint because the complaint is all hearsay. What the jury is going to see is the evidence. So it's not going to hold a lot of weight with the jury.
Okay, thank you.
That complaint, what was put in that complaint is not going to hold weight with the jury. What's going to hold weight with the jury is the actual evidence that's presented. That's what matters.
got a couple more here. Can't JonesWorks other clients sue for potential breach of confidentiality if they were clients of Nathan simply by handing over a company phone?
That's interesting. So what happens if there was information on that phone related to other clients and their confidential information? Yeah, I think that'd be a problem.
Tom Brady is going to be coming for him.
Yeah. Don't you think that'd be a problem, sir?
It could be Vipan, and thank you for the question. And that is the problem with these phones is they hold so much data.
Yeah.
And in fact, maybe whoever turned this phone over didn't know how much data was actually on there. And so, yeah, anytime you turn over somebody's trusted information that they've trusted you with, and you have a confidentiality agreement, or even if you don't, and it's just assumed that you wouldn't turn this stuff over, you're opening yourself up to nasty letter at the easiest, and then a lawsuit at worst.
I guess it's possible that JonesWorks only handed over text messages off of that phone between Melissa Nathan and Jen Abel. I don't know I don't know that the entire phone was handed over.
Well, that's why we need to see the subpoena. What
Yeah.
was actually demanded? What communications were demanded?
Well, and that's the discovery Friedman's going to do. He's going to want to know,
Right.
what did you hand over? When did you hand it over?
Right.
Again, we might not know all this, but Yasmin Khan wants to know, was subpoena confirmed for Jennifer Abel's phone? Seems like they viewed Abel's and subpoenaed Jones, or was Stephanie Jones fired before emergency PR texts that were used in the CRD New York Times? That would confirm the phone's owner.
Stephanie Jones was fired before the CRD New York Times. That's for sure. I mean, I think that all happened before that. I mean, I think that's what led to a lot of this.
Yep. Okay, thank you. We got just a couple more. Annalisa says, you are 1, not boring at all.
Thank you.
2, the most analytical and super, I'm not sure what that's supposed to say, but good, super creators out there. It's always both entertaining and educating to listen to you.
Thank you.
Thank you.
Yeah, thank you very much.
Well, yeah, that's this chat has been flying today, but that's kind of all I got for right now.
Okay, we're at the hour mark, and man, that was really great to have Josh Boswell on.
It was great, yeah.
It was nice to hear his point of view and kind of dig into that. And I think we actually gave him some insight that maybe he hadn't thought of on the subpoena issue with California and all that.
We'll see what he writes about next.
Yeah, right. It'd be good if he got in there and dug that up.
Yeah. So you guys are going to be on Zach's show tomorrow, 9 a.m. Pacific, No Filter with Zack Peter.
Awesome.
Yeah.
Yeah, we always look forward to being on with Zach. That'd be great.
Yep.
And so read the Atlantic article. It's linked in the description. It's a really, really awesome piece. I think you can sign up for a 30-day free trial as well too. So it does have a paywall, but yeah, check it out.
All right. We'll see you guys next time. Thanks for joining us.
All right, take care.
We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.